Good morning to all of you. Andarki Shubhodayam. Welcome to Legal Matters by Sai Babu Sukar. In this video, we are going to discuss a point whether maternity leave benefit can be availed for the third child or not in Tamil Nadu state. Normally, there are service rules and fundamental rules in Tamil Nadu state which state that the maternity leave, which is the reproductive right, can be given to the two children only, not for the third child. However, when the matter came to the Supreme Court, they said that in this particular case, the third child can also, for the third child, the mother can get the benefit of maternity leave. Why and how? Now we are going to study. Justice Abhay Srinivas Vokha and Ujjal Bhuyan in the case of K. Umadevi versus State of Tamil Nadu, Civil Appeal number 2526 by 2025, decided on 23rd May, yesterday, 2025, wherein Honorable Supreme Court bench held that maternity benefits are part of the reproductive rights and maternity leave is actually integral to these benefits. Therefore, maternity leave can be granted for the third child also, considering it to be a reproductive right. Coming to the facts of the case, actually, this Umadevi, she married Suresh in the year 2006. As a result of the beautiful wedlock, they have given birth to two children. By 2011, two children were born to them. But, of course, in the year 2012, she entered the government service as a teacher, English teacher, in a government higher secondary school, P. Gollapatti of Dharmapuri district in the state of Tamil Nadu. But differences cropped up between them and they parted their ways in the year 2007 by dissolving the marriage. That means divorce was granted. The children are with Mr. Suresh, not with this woman. In the year 2018, that is on 12/9/2018, she remarried Rajkumar, or she was married to Rajkumar. So as a result of the marriage, she became pregnant, and since she was working as a teacher, she has applied for medical leave for 9 months, that is pre and postnatal period, 9 months. She has applied from 17/8/2021 to 13/5/2022, pre and postnatal periods. But it was denied by the state. State did not agree, basing on the FR 101A. Because, please remember, as per the fundamental rules 101A, no maternity leave or maternity leave will be available only for women having 2 or less children. Of course, now the days are changed. In Andhra Pradesh also, a person who is having more than 2 children is not eligible to contest as a Sarpanch or Mandal Parishad president. But now, Honorable CM Chandrababu Naidu sir, he himself is saying, come on, you give more children. That clause has gone. You get more children because of the demographic dividend, which I will discuss later. Not in this video. Right. So, since the government has not allowed, she filed a writ petition, writ number 22075 by 2021. Single judge allowed, and he said that she was entitled to medical leave or maternity leave. So, the directions of the state, they were stayed, and she has to get the maternity leave benefit and picture. Then the government, they did not keep quiet. They approached the division bench. Single judge meda division bench keltar. Division bench, so they have dismissed the single judge's order stating that on 14/9/2022, that means almost after 1 year, she is not eligible because of the conditions of the state. A woman having 3 children, she is not eligible for maternity leave. Now the matter has come to the Supreme Court. Here, Supreme Court discussed at length about the Act. Interpretation students, please remember, read it or hear it thoroughly. So you have to understand the legislative intent. No doubt it's a central government act. But you have to understand the legislative intent. When it is a central act, automatically it applies to the state also. It may not be directly applicable to the state government employees, but when it is a central act, you have to read it with the legislative intent. The intent is to protect the motherhood and complete care when she is not able to perform her routine duties due to the pregnancy. It reflects on the Article 21 of the Constitution of India, which says about the right to life and liberty. Article 42 also a bit relevant here. Article 42 says, state has to make just and humane conditions of work and maternity relief. For that purpose only, maternity benefit has come into existence. Now Supreme Court discussed the international arena also. International law. So even our Article 51C of the Constitution of India, you have to foster respect to the international law. Right. And Maternity Benefit Act, Section 5 of the Act, did not say about any number of children. Now, going to the international law, UDHR, Universal Declaration of Human Rights, Article 25. So, it says motherhood and childhood, special care should be taken. When special care should be taken, she has to be given leave. ICSR, International Covenant on Economic, Social and Cultural Rights. Article 10, Clause 2, special protection to the mother. Then CEDAW, CEDAW, that is Convention on the Elimination of Discrimination Against Women, Article 21, Article 11. So effective right to work. So like that, they have given this also. So definitely, it is a broader spectrum of reproductive rights. Definitely, she has to be given maternity leave. This is the observation of the Honorable Supreme Court of India. And in this connection, whenever the interpretation comes, we will be telling the case of B.Shah versus Presiding Officer, Labour Court, Coimbatore, 1978 case, where this woman who was given maternity leave, she used to be paid on every Friday for the 6 days. Every Saturday for the 6 days of work. 7th day, Sunday is eliminated. 72 weeks ki 72 days tagiste, then court did not agree because it is definitely a beneficial legislation. Court held that it is a beneficial legislation. Likewise, Supreme Court relied on some other cases like Suchitra Srivastava versus Chandigarh Administration, 2009. Devika Bishwan versus Union of India, 2016. Anyway, ML is granted. It's a good sign of relief to this woman, particularly by the Honorable Supreme Court of India. So when Supreme Court of India says you are bound over and now going to appeal. So very good decision by the Honorable Supreme Court of India. Read it and enrich your legal knowledge. Thank you.